Assalamualaikum and a very good day. Today I'm going to present a research paper entitled Sharia and Civil Legislation in Malaysia on Child Testimony in Sexual Offences. The presenter is Asmida Ahmad, that will be me, and the co-author will be my supervisors, Professor Dr. Muhammad Nasran bin Muhammad and Associate Professor Muhammad Al-Adib Sam. Okay, for the introductory remark, okay, for this paper, as we all know that rights to be heard and equality before law are basically enshrined in Article 5 and 8, respectively, in our federal constitution. And for the spirit of these such constitutional rights for the child, Malaysia has ratified the UNCRC, or better known as well as United Nations Convention of the Rights of the Child, in 1995, and at the same time also Malaysia has affirmed these some reservations on some articles. In regards to the one of the rights under UNCRC which Malaysia ratified and acknowledged will be on the rights to a fair trial and equitable in the justice system. This shall also include on the right of a child testimony to testify in any trial, which is stated also under Article 12 of the UNCRC, or this convention, that a child must be given an opportunity to be heard in his or her respective cases. So, in line of this ratification and the rights mentioned just now, Malaysia has introduced the Child Act 2001 Amendment 2016, which hereinafter in this presentation will be referred as Act 611. And at the same time, along the line in 2007, also pursuant to the passing of this Act 611, evidence of Child Act 2007, and hereinafter will be referred to as Act 676, was enacted to govern all relevant procedural laws pertaining to the evidence given by a child in a court trial. So in lieu to this procedural law relating to criminal proceedings, a child testimony would also need a cross-reference to the Criminal Procedure Code, hereinafter also in this presentation to be referred to as Act 593 and Evidence Act 1950, which is also will be referred to as Act 56. Okay, with adjustment since the parties involved are children. So these three statutes will be cross-referred, and these particular research also will be doing a comparison with the rights of the child testimony in the Sharia court of the states in Malaysia. Looking at the problem statement for this paper, as what we all know, in regards to the child testimony, with the escalating number of children that involved in the sexual and other offences has actually attract the criticism. Attract the criticism over the efficacy of the child courts, especially. For example, that there has been a criticism in terms of the experiences, in child testimony due to their tender age and trustworthiness. At the same time, there are also, it has been evidence also that there has been a fear of the child witness themselves of seeing the perpetrator physically during trial, and at the same time, it affects their physiological distress. Describing the details of the alleged crime has made a child reluctant at the same time to testify, as well as may decrease the accuracy of the testimony. Moving forward, looking at the research objective for this paper, it is to examine and scrutinize the position yeah, the position and the admissibility of the evidence and testimony given by a child involved in sexual offences in the current courts in Malaysia, which are the Court for Children, Sexual Crime Court Against Children, and Syariah Court. Yeah, and there has been a criticism over the credibility, as I have mentioned just in the problem statement, a criticism in the sense that over on the credibility of a child when it comes to giving evidence and testimony due to their tender age, as well as their trustworthiness, which may be rejected and inadmissible by the relevant courts. The research, in terms of the research methodology, qualitative study is used with focus on the provisions of laws, as I have mentioned just now, related to the evidence and procedures given by child during criminal proceeding. So this outcome of this study, yeah, shall further identify and provide some suggestions to be considered in respect of certain imprecision of laws as to be highlighted later on. Okay, so the governing laws and applicable provisions that will be referred to in order to identify such a position and the admissibility of child evidence and testimony would be the act that I have mentioned just now, i.e. the Act 611, Act at 56, Act at 676, with a comparison in related provisions in the Sharia Court Evidence Act and the Sharia Procedure Act of the states in Malaysia. Right. Okay. And looking at the basically, yeah, before I go to this child testimony under the civil and Sharia legislation, let me just give you of an overview, yeah, of the criticism over the child testimony in sexual in Malaysia. So basically, the commission of these sexual offences by children is not a new issue. Yeah, as a matter in fact, it is a global issue. Yeah, that faced by the society. Right. Hence, for a child who is arrested as a suspect in sexual offences cases, the child normally will be brought before the special court, which is obviously a court for children in Malaysia, where the suspect will be tried in a proper criminal proceeding. And as a matter of a fair trial, of course, the witnesses, yeah, and the victim will be called upon to testify as well as giving evidence. However, the trial for children here facing some challenges where specific guidelines and provisions of laws must be followed, must be adhered, must be observed, yeah, where justice and their rights must be protected at the same time. Yeah, since the offense was committed at such a young age. Okay, so at the same time, yeah, as I have mentioned earlier under the problem statement, with the increasing numbers of children involving in sexual offences, the performance, yeah, the general criticism that was would be on the efficacy of the juvenile justice system itself. Firstly, the case handling in the child courts, for example, be it in the courts for children, sexual crimes court against children, as well as the Sharia court. The performance of child court judges was heavily criticized for poor handling child adolescent cases and uh, inexperienced judges which may affected the court proceeding and the judgment. Okay, so for that is on the what do you call that, the efficiency or the efficacy of the court itself. And when we are talking about the court trial itself, another similar experience in the child evidence and testimony, which has also negatively affected in these three existing courts which I have mentioned just now. For example, there are fears that the child has about testifying in the court when he or she sees the perpetrator, or a fear that the accused may harm him or her. And for others, there may be a psychological distress affected when they are seeing the perpetrator again. And apart from that, another issues or problems that may arise in referring to the in referring to the futures of the trial proceedings, such as facing the accused or describing the details of the alleged crime in the courtroom, may make the child or the children reluctant or refuse to testify or give evidence, in which at the same time may decrease the accuracy of the testimony. Hence, the evidence would be inadmissible. All right, so based on this issue, the child needs legal intervention in terms of special protection and fair treatment, as there are vulnerable. Okay, so when we are looking at the child testimony and under this civil legislation, one thing that we can see here is that, yeah, that can be identified here. For example, there is an ambiguity, yeah, in the act itself, yeah, and in the act itself, for example, looking at the definition of a child itself, for example, under section 2 of Act 611, yeah, would be those who are 18 years old and below. All right, and if we are referring when we are referring to this act, yeah, it is understood that when involving a child in the court proceeding, yeah, he or she can be an offender or accused or victim or witness. However, under Act 676, yeah, compare between the definition under Act 611 and 676. In Act 676, such definition of a child is only confined to child witness, rather than covering the other types of child on trial. For example, as an accused or offender, no victim which directly can be said that it didn't protect the rights for a fair trial to the accused, especially who is also a child. So to be more precise, in another word here, such privilege and eligibility is given only to a child witness who are 16 years old and below, which clearly shows that the recognition for this type of age group only. Yeah, if you when you refer to the section 2 of the Act 676 itself, yeah, it stated that child witness means a person under the age of 16 years old, and so on. All right, so this would mean that, yeah, if you when you refer to what has been mentioned just now under section 2 of 676 study, Act 676, this would mean that those witnesses who are above the age of 16 and 18 years old are not subjected to any entitlement, yeah, or such or any privilege, nor enjoy any special facilities under the Act of 676 when giving evidence, since they didn't fall under the category age group. Right, so obviously it is clear that there is a loophole or lacuna based on the age definition in both Act 611 and Act 676. Okay, so that is one loophole that can be clearly identified about the child testimony comparatively with at the child testimony in the Sharia legislation. Yeah, looking at the Sharia position, a stricter requirement, yeah, is given for child testimony, yeah, as consideration for a child testimony to be made admissible. Yeah, is basically determined and subjected to the child must reach the age of baligh, yeah, baligh age, yeah. in order and to prove the baligh or so-called puberty here, yeah, puberty age is certainly not easy as prescribed in the hukum syara, yeah. Obviously, because there is no definite answer to prove that a person has reached the age of puberty if his mental capacity is still unable to differentiate which is good and bad for him or her, right? Okay, so in the again, yeah, further in Sharia law perspective, yeah, uh, uh, in the current position here, in the current position in the Sharia court in Malaysia, uh, their testimony, when the testimony is given in the Sharia court, yeah, yet their testimony would be admissible as a bayinah, yeah, as a bayinah instead of shahada. Shahada means testimony lah. All right. So what do you call that? In another word here, yeah, Muslim jurists, yeah, had put certain limitations or restrictions, yeah, on child evidence and testimony as admissible, simply because child lacks of the child are lacking of understanding and discerning power, which is inherent in persons of tender age, yeah, thus preventing the children or the child from understanding the nature of certain events. Okay. It can be concluded here, it is submitted that, yeah, to ascertain the actual age of puberty or baligh, yeah, is not easy, yeah, as there is no clear indication of a specific puberty age in any of the Sharia Court Evidence Act of the states, yeah. For example, yeah, taking an example here under section 83(1) of the Sharia Court Evidence of the Federal Territories Act 1997 provides that, yeah, all Muslims shall competent to give shahadah or bayinah as witnesses, provided that they are aqil, baligh, adil, yeah, and have a good memory and are not prejudiced, yeah. And further, under subsection 4 of the same provision, yeah, of the Act provides that a person who is not baligh or a person who is of unsound is competent to give bayinah but not competent to give shahadah. All right. So nevertheless, yeah, the explanation to this subsection stipulates that, yeah, the shahadah of a child in those cases can be accepted as long as there is no enmity between them. However, yeah, the issue here is that what if the person is capable of understanding and able to distinguish a good and a bad thing, yeah, as well as a trustworthy, although he or she is a child. Okay, from here another loophole or lacuna, yeah, in the provisions, yeah, which require further consideration for the law to be revised, in Sharia law to be revised. Okay, so meantime, if we compare with the what is provided in the Evidence Act, Act 56, by virtue of Section 118, the main consideration in accepting the evidence of a child is the capacity to understand the questions that is put to them, and the intellectual capacity of the child, rather specifying any particular age. All right, so hence, yeah, it is important to take note here that where that a careful consideration in accepting a child's evidence and testimony has to be taken into account here, yeah, in order for the justice to be served, and the rights of the child at the same time are protected. Moving on, looking at the other challenges, yeah, faced by both legislation in the child testimony, which can be drawn here, which can be identified here. Number one will be hearsay, yeah, hearsay. All right, as what we all know that general rule for hearsay, yeah, accepting the hearsay in evidence, yeah, in testimony, yeah, is inadmissible. All right, we need to say we are not accepting the law of Malaysia, the legal system are not accepting the third party testimony. Yeah, is admissible. All right, so in regards to the child testimony, yeah, hence in regards to the child evidence, the same principles obviously shall apply, whereby the testimony which is given by a third party on what the person heard or received from a child outside the court proceeding is not to be considered or inadmissible unless the child is present and testify in the court for cross-examination stage. Again, yeah, the protection of the child is being challenged, yeah, in the event that the child is unable or not fit to appear in the court to give evidence or testify due to certain or some justified reasons, yeah. I mean, as far as the hearsay is concerned, the third-party evidence and testimony is admissible, obviously, because it is a hearsay, like I have mentioned just now. And apart from that, any other form of a child evidence, like written recordings, notes, audio recordings, etc., cannot be used as evidence by the court, as these are forms of hearsay. Yeah, hearsay evidence or evidence from the third party can only be accepted if the third party satisfied certain or specific conditions to their credibility as provided under Section 32 of Evidence Act, yeah, Act 56. Yeah, due to these strict provisions, again, yeah, has led to the to difficulties in the court proceeding itself. Okay. And the second, I mean, challenges, yeah, second challenge that is identified here will be in terms of the testimony via uh, video recording, yeah. So video recording obviously is what we call that has been is one of the most important what we call that types of evidence, yeah, that is of course acceptable and has been used, yeah, has been used in the child testimony, yeah, because of certain reasons which I have mentioned before. All right. Uh, Such has been actually has been mentioned, yeah, in the Act 676 itself. 676, yeah, Act 676, what do you call that, video recording, yeah, of a child, yeah, can be used, yeah, whereby the child testimony and evidence will be taken via pre-recorded form, right, in a child interview center and submitted to the court before the actual trial takes place. All right. However, there is an issue that has been identified here at the when it comes to the cross-examination stage, when the child is required to answer certain queries from the opposing party, or further explanation and details are required from the court, or the pre-recorded testimony and evidence was insufficient to prove the case, where the child presence is still required at the trial. Okay, so due to this, yeah, this situation would definitely create more problem where the child is still bound to be at the trial and going through the cross-examination stage and facing with more questions that can only confuse as well as possibly to get the child more traumatized. Uh, so these are the two areas, I mean the two challenges that have been mentioned just now. And finally, on the recommendation for the, I mean, the lacuna or the loopholes that has been mentioned just now. Hence, yeah, it is suggested to have amendments in both laws actually, yeah, to have a similar definition of child and child witnesses, as well as to determine, yeah, setting a similar age limit for all three legislation, as well as in Sharia court to determine the actual age of baligh, yeah, so that a proper what do you call this procedure, yeah, child I mean trial, yeah, can be correctly carried out. And the second recommendation here in terms of the hearsay evidence, yeah, recognition, yeah, of hearsay evidence, yeah, is highly recommended to be accepted in the extreme or dire situation where the child, when the child is found to be unfit or impractical to provide evidence directly, as well as to cater a better and current needs, yeah. And the third recommendation here will be the acceptance of video recording in three stages of criminal proceedings: examination in chief, cross-examination, and re-examinations. Okay, as a concluding remark here, with these several witnesses and loopholes that has been discussed and highlighted in both legislation, Sharia and civil, it is hoped that these provisions are to be looked into for possible reviewing and revamping. Yeah. Uh, with that, I thank you.